Statutory Corporation of Trinidad and Tobago.
Mr. Ford.
My lords and my lady, good morning. Kendall Alexander, instructed by John Almeida for the respondent, Anand Ram Logan, Jessica Boyd, and myself, instructed by Alvin Pariag Singh for the appellant. You have the agreed facts at bundle page 262 and the issues at bundle page 267. The big issue is issue 3. And in deciding issue 3, the approach to hardship, prejudice or detriment when a leave stage judge in judicial review is facing a delay objection, will also decide issue number 1, who was right. The other points I will deal with as I go along. Some of them I'll leave till the end. So far as the facts are concerned, I just want to emphasise 5 or 6 points at the start. First, my client was president of the Indo-Trinbago Equality Council, seeking information under the Freedom of Information Act for the reasons he explains in his affidavit, pages 20 to 21 of the electronic bundle, and it's paragraph 38.4 of our case. Secondly, a statutory exemption was raised, which proved to be ill-founded. There was a duty to provide this information under the Freedom of Information Act. That's the next subparagraph in our case, 38.5. And that's because that same issue was resolved in parallel judicial review proceedings, indeed had been resolved by the time that the judge removed the leave that he had previously granted in these proceedings. So that was known by the time leave, which had originally been given, was then set aside. Next, this is not a case where it was said that our client should have filed within 3 months. What was said by the judge when he set aside leave was that we should have filed after the 8th of December 2009 instead of filing when we did on the 20th of January. That was the delay that the judge regarded as fatal, and the Court of Appeal upheld him. There was no prejudice or hardship or detriment. None was relied on before the judge, and when the Court of Appeal asked about it, it was specifically confirmed that there was no prejudice. And that's why we've given you 2 letters that I'm afraid were missing, but they're referred to in the papers. You might have felt it was left somewhat hanging. The judge, at the very end of his judgment on page 114, refers to a letter of the 29th of April. It's referred to in the agreed statements of facts and issues, but you didn't have it until now. This was a letter from both parties confirming that the linked parallel judicial review had now been resolved and the exemption had been rejected. And I might add that in that parallel judicial review, a delay point had been raised, but judicial review had been granted. So that's just for the sake of order, so you've got that. And similarly, at the end of Justice Afil Jamadar's dissent in the Court of Appeal, at page 193 to 194, he refers to another letter. Again, it's referred to, but you didn't actually have it. And it's the other letter we've just given you, 30th of September 2016, confirming no evidence of prejudice, detriment or hardship. And indeed, you'll see it also records the position that Abzal Mohammed had settled the question of the approach. Well, the Court of Appeal thought not, and that's why we're here. Can I turn then straight to that central issue? You've seen it formulated on page 267. Is lack of promptness or unreasonable delay, if they're different and they're not, a basis of itself for refusing leave if you're the leave judge, or for setting it aside if you're asked to set it aside, without having regard to, and then 3 things. Good reason for the delay, good reason to extend time, and I'll call it degree of prejudice. Acronyms work in printed cases, perhaps they don't work so well orally. Degree of prejudice. Whether and to what extent there is relevant hardship, prejudice or detriment. The answer to that question is no. There is no basis for either refusing leave or setting it aside on the basis of delay simpliciter. You have to go on, as the leave judge, to look at good reason, and it's not good reason for delay. It could be, but it isn't. It's good reason for an extension of time. That's, in the end, a public interest balance. And the good reason to extend time, which is essential, and the judge didn't go anywhere near because he stopped at unreasonable delay, includes within it considering whether or not there's prejudice, the degree of prejudice. And there are two ways one can put it, and I'm going to give you both options. We've given both in our written case. You can either see it as an overlapping question. So the question of the good reason to extend time overlaps with another question, whether to refuse leave for hardship, prejudice or detriment. So two circles that overlap, that's one way of looking at it. That's good enough for us, because if there's a principled overlap, you have to consider it. And I'll show you a good example of that approach is Mr. Justice Maurice Kay's judgment, as he then was in the English case of Greenpeace. It's quite an influential case, and it's a really good illustration. The other way we put it, which is bolder, but better, or even better, we submit, is that in fact there is a fusion. It's much more straightforward than a route to verdict that has three questions in it. Once you've got relevant delay, which is question one, you can't refuse leave on that basis. You have to proceed to question two, and question two is an overall public interest balance where all factors will be relevant. It's approached in a holistic way. That was the way the dissenting Justice of Appeal Jamadar saw it, and he was right. So there's no insulated question of delay simpliciter. The judge was wrong, so was Justice of Appeal Smith in agreeing with the judge. And there's no insulated question of good reason. And by insulated, I mean, let's leave aside hardship, prejudice and detriment because they're separate. They come later only if you reach them. It comes to this. Before you, as the leave judge, refuse leave for judicial review in a delay case, or if you're asked to, before you set it aside for delay, the applicant is entitled to have the degree of prejudice duly considered. That's the proposition. That's what the dissent holds. We submit that is correct by either of the two routes, either because of the principled overlap or because of the fusion.
What is it you say overlaps, Mr. Ford?
What overlaps is the issue of whether there is hardship, prejudice or detriment.
Overlaps with what?
It overlaps with whether there's a good reason to extend time.
Right. Thank you.
But why do we say that the applicant is so entitled? Firstly, because prejudice can cut both ways. It's not just that prejudice is something that counts in favour of respondents and interested parties. The absence of prejudice counts in favour of the applicant. And unless either of these two models is correct, the applicant faces the situation that is unfair. A respondent and third party can always have hardship, prejudice and detriment looked at by a leave judge in a delay case before leave is granted, but an applicant can't have them looked at by the leave judge. Leave can be refused on the grounds of delay without looking at them. So an applicant must in principle be entitled to invoke the absence. It's a key feature of a balancing exercise which ultimately is about the public interest. And as soon as one breaks away from the idea of good reason for the delay, which is not the test, then one is into that balancing exercise. But the shortest point of all is that there is a rule that says so. In Trinidad, there is a rule of the Civil Procedure Rules, 56.53, which says that before you refuse leave because of delay, you have to consider it. And there is the rule maker mandating the principled overlap or the fused question.
Am I right in thinking, Mr. Forden, there's no equivalent in
Correct.
this jurisdiction to
Correct.
that provision?
Although I make clear, if I were in the comparative world of an English case making submissions, I would be making the same principled submissions. But in Trinidad and Tobago, you're right, the rules are different. So is the statute. I mean, one obvious way that the Act is different that you may have spotted is that Section 11, subsection 3 on bundle page 353. Sorry. Yes, 353 in Authorities Volume 1. Says the court may refuse to grant leave to apply for judicial review if it considers. Now, in England, you'd have an A and a B, where A would be leave and B would be relief in that provision. That is only a leave.
Sorry, you're
Section
referring to
11,
Section 11,
subsection 2, top of page 353. The court may refuse to grant leave to apply for judicial review if it considers. If we were in an English case, you'd find or relief in the equivalent, which is Section 31, subsection 6 of the Senior Courts Act 1981. In Trinidad, it's dealt with in the rules, because back at 56.5, page 361 of the same bundle, you get leave or relief in 56.51 and 56.53. But my Lord is right, there are differences. I'm not here to try and win an English case, and I'm going to restrict myself to the position under the law of Trinidad and Tobago, but I will show you some comparative law because it's illustrative. So there's a rule. That rule, interestingly, is referred to by the respondent in their case, paragraph 15. They make no further comment on it. It's not said, oh, well, rules have to be consistent with the statute. This rule's inconsistent with the statute. See Fishermen and Friends of the Sea earlier this year, and here's the inconsistency. There's no inconsistency with the statute. The statute makes provision that rules can be made. It's section 24 on page 357. Clearly the rules do then make further provision, and this is one of the further provisions that's made, and they put this issue beyond any doubt in our submission. I cannot be thrown out of court at the leave stage for delay without this having been thought about. So, before I turn to the two ways we put it, can I attack the two ways that it's put against us? The first is the delay simpliciter point, why the issue is structured in the way that it is. And this was the judge's thesis. We deal with it in our case at paragraphs 12 to 14. Can I just suggest the route to verdict for this approach, and then we'll analyse it. The route to verdict for the leave judge, under the judge's approach, is you ask this question: am I satisfied that there was unreasonable delay? Unreasonable delay, as the words suggest, delay for which there was no good reason, so reason for the delay. And if I am satisfied, I refuse leave. And I stop. And that approach is evidently based on reading 56.5 of the rules on page 361, 56.5 subparagraph 1 in isolation. That's what the judge evidently did. We'll look at it in a moment. So here's the question. Do I consider that there's been unreasonable delay before making the application? And that's it. I can now refuse leave because rule 56.51 tells me I can. We deal with this at paragraph 8. We set it out, but you've got it in lots of different places. Now, the respondent defends that position at paragraphs 17 and 18 of their case, pages 319 and 320. So you're entitled to do that, and the judge was right to do it. Not only that, Justice of Appeal Smith in the Court of Appeal adopted this approach, agreed with the judge, and the respondents also defend him. That's their paragraph 9 at page 314. So what did the judge do? The court has the reasons at page 109 in the record. All my pagination is to the electronic one, so I won't keep using the word electronic. 109, the judge's reasons. And he sets out the facts and the chronology, and his conclusion is at the bottom of 113. Paragraph 15, no explanation for the delay after the 7th of December. I'm going to come back to the sequence of events. In my view, it's appropriate to consider that time should run from the decision being communicated. No proper explanation for filing beyond the 3 months. I also did not think the letters passing between the attorneys was sufficient reason. No suggestion the claimant shouldn't file his claim. Wasn't misled. No reason, at the very least, no reason for further delay after the 8th of December 2009 letter, 6 weeks. I therefore found that there was unreasonable delay in filing the claim, and I set aside the order giving leave to the claimant. The last paragraph is the one you know about, that talks about the letter that you've now got. So that's it. And that's the approach, and the respondents say that that's available to a judge. So I'll deal with it. I can deal with it briefly. We deal with it at paragraph 14 of our written case. It's wrong because unreasonable delay in 56.5 has to be read with the other rules. And in fact, you only have to look on the same page to go down to 56.5.3 to see why it's wrong. Because you do have to consider other features, and specifically you have to consider whether, yes or no, to what extent there's hardship, prejudice or detriment. It's wrong because unreasonable delay is one of the 3 descriptors that are used, and there are 3, for relevant delay. The 3 are these: Section 11, subsection 1, promptly and in any event within 3 months, page 352. Descriptor number 1 for relevant delay. Number 2, top of the next page, undue delay in making the application. Back in 56.5, unreasonable delay before making the application. So these are all descriptions of stage 1. Is there relevant delay? If there's not relevant delay, that's the end of the delay point. It doesn't mean you grant leave, because you've got to have an arguable case and no alternative remedy, and so on. But that's what these phrases are doing. And of course, it's very well established in the comparative world of England and Wales, right back to Jackson in 1985 and Caswell in the House of Lords, that undue delay and promptly and in any event 3 months are the same thing. They're different language, but they're the same idea. You read them together. Yes, it's clunky, says the House of Lords, and so it is. But that's what it is. It's what raises the question. It doesn't provide the answer. It's wrong, next, because what it would mean is you'd subvert the rule in the statute that says you need a good reason to extend time. And you'd subvert that rule because instead you'd be looking at the good reason for the delay in asking, is there unreasonable delay? It's wrong because you always have to proceed, where there is undue or unreasonable delay, to the good reason to extend time. And that's what the legislature has said in section 11, subsection 1. You cannot refuse leave because of delay without asking whether there's a good reason to extend time. So for all those reasons, if you just look at the rules, and the rules read as a whole, if you look at the statute, if you look at them together. Now, Justice Appeal Barrow in the Court of Appeal spotted this and dealt with it in a slightly different way, although rather odd because he also said he agreed with Justice of Appeal Smith. But Justice of Appeal Barrow, you'll find at paragraph 12 on page 211 of the record, saying, it appears that he, that's the judge, may have confused 11.1 and 11.2, 56.5.1 and 56.5.3, paragraph 12 on page 211. And then it says this, however, at the end of the day, the objection taken by the respondent was the lack of promptitude in 11.1. That did not require the consideration of prejudice to a third party or detriment to good administration. That's the big point in this case, about whether you can simply strip it out and put it to one side. The judge would then have had to consider whether he had good reason to extend time. As I've already noted, even though he gave no express consideration, he obviously found there was no good reason. Well, there's simply no basis for that. He doesn't deal with no good reason to extend time. He deals with no good reason for the delay. And then this very odd sentence, but in any event, as agreed between the parties, the sole question which arose for him to consider on the promptitude question was pure delay. Now that reads as if Justice of Appeal Barrow is saying the parties have agreed that the only question is the undue delay question, or the lack of promptitude, and in any event within 3 months question. And therefore the parties had agreed there was no issue about extending time. And that's simply wrong. I mean, firstly, and this is issue 7, there's no basis for inferring this reasoning into the judgment below. It was wrong to do so. But the position as to what was agreed, you can see, we've now got the letter, but what was agreed was the merits were no longer going to be contested, and the judge himself records that at paragraph 17 on 114. You saw it at the bottom of the page. So the respondents are no longer contesting the merits. There's no exemption. They got it wrong in law. We have a right to the information. And what's happened is that because the merits are no longer contested, the only issues are delay. Are you going to throw me out as being too late, even though I'm right in law? And then the question of costs. And the issue as to, are you going to throw me out because I'm too late, even though I'm now vindicated as right in law, included the extension of time. There's an agreed fact at paragraph 4 on page 263. And therefore, paragraph 20 of the respondent's case is baffling. They say we were only taking the position that there'd been no relevant delay. We weren't asking for an extension of time. But paragraph 4, in the agreed fact...
Sorry, you're on page?
263. There was before the court an application to extend time. Not only that, there was oral argument before the judge on the question of the absence of prejudice. Oh, I'm sorry. I should keep telling you that when we're talking about different bundles for those who are paper, so 263 is in the documents filed in the appeal.
Oh, thank you.
I do apologise, my lord. That's where you will find the statement of facts and issues at page 262. The issues at page 267. It's my fault and I'm sorry.
I'm working off a different...
And at 263, anyway. I hope the board has that.
Paragraph?
4. Agreed fact. And just while you've got that page in front of you, the 2 letters I gave you are the letters referred to at the end of paragraph 5 is the one that was sent to the Court of Appeal.
You.
Yeah. So that's unreasonable delay. raises the question, it is not the answer. I turn to the other way that it's put. And this was really Justice of Appeal Barrow's approach, leaving aside the agreement with Justice of Appeal Smith. And that is that good reason to extend time is more than good reason for delay, but it doesn't extend to hardship, prejudice or detriment, presence or absence, because that's a distinct stage in the route to verdict that you may not need to get to. And I showed you already that in the middle of paragraph 12 at the end of Justice of Appeal Barrow's judgment on page 211, you've got that did not require the consideration of prejudice to a third party or detriment to good administration. That's the stripping out. And Justice of Appeal Smith reinforces it at paragraph 26 on page 204, where he says these considerations of prejudice, hardship, prejudice, detriment, and the degree of them only apply to what he describes as a residual discretion. But how does the logic work? Let's address the logic first, and then I will attack it. The logic goes as follows. You can see it from the three questions that are posed by Justice of Appeal Barrow, which we deal with in our printed case at paragraph 19, if you want to see them set out in secondary form. Our paragraph 19, my lord, is at page 282, and it's at the bottom of 282. So, three issues for the judge set out there in paragraph 7 of Justice of Appeal Barrow's judgment. And for those who are reading it in the judgment, it's page 209 of the record. So here's the combined effect. Question 1, whether the application was filed promptly, in brackets that would be undue delay, unreasonable delay. That's the relevant delay question. Question 2, if it wasn't, is there good reason to extend time? If not, refuse, leave for lack of promptitude. That phrase is illuminating. That means refuse leave because of delay. Why do I emphasise that? Think back to Rule 56.3. You can't refuse leave because of delay without considering something. So that's stage 2. Stage 3, if you've got good reason to extend the time, then you look at whether leave, he's now calling it permission, should be refused on the grounds that remedy would be likely to cause hardship, prejudice or detriment. So what does your route to verdict look like if you're the leave judge in Trinidad and Tobago based on this, based on the fact you strip out prejudice, hardship and detriment? Your route to verdict would look like this. Ask yourself, do I consider that there's been relevant delay? Because it wasn't prompt in any event within 3 months. Same as undue delay, same as unreasonable delay. If no, proceed to the other issues. Is the case arguable? Is there an alternative remedy, etc.? Is the body amenable to judicial review? Because that's the end of the delay objection. If yes, it wasn't prompt, there is relevant delay. Secondly, ask yourself this question. Is there good reason to extend time, leaving aside hardship, prejudice and detriment? If no, refuse leave because of delay. There isn't good reason to extend time, leaving aside questions of hardship, prejudice and detriment. If no, refuse leave because of delay and stop. That's the route to verdict. If yes, extend the time and go to question 3. Why do I say that? Look at the start of paragraph 8. That is the logic in this world. You extend the time on basis of the good reason, without having considered that other topic, and then ask a different question, should leave be refused on grounds of hardship, prejudice and detriment? If yes, refuse leave. There are two ways to refuse leave on grounds of delay, and one of them involves putting to one side the issue of hardship, prejudice and detriment.
Do you have to put that to one side? Because somewhere you have to get what good reason is. And in section 11, subsection 3, the court's told that in forming an opinion for the purposes of the section, it can take into account other matters as it considers relevant.
Yes, it does.
So you could put that into the equation, couldn't you?
Well, that's our position is, firstly, you don't strip them out. And secondly, not only could you put them into the equation, you should put them into the equation as a matter of principle. And if there were any doubt about that, 56.5.3 resolves it. Because the end of Justice of Appeal Burroughs 7.2 doesn't work with the middle of his paragraph 12 on 211. Didn't require the consideration of prejudice or third party or detriment to good administration. When you put that alongside the rule, you cannot refuse leave for judicial review for lack of promptitude without considering prejudice to a third party or detriment to good administration, consistently with Rule 56.5.3. Flatly inconsistent. So I will build this up because our submissions are that not only can it be, but it should be, in principle, within good reason to extend time. This approach is defended by the respondent at paragraph 20 of their printed case. And here we are directly in the issue that the Privy Council left open for this case when you decided Fishermen and Friends of the Sea earlier this year. Volume 1, tab 13 in the paper, bundle page 701 in the electronic, paragraphs 24 and 25. Because you'd been shown the conflicting authorities, and you knew the point was coming. And here it is. So the first way we put it, which is the more modest way, is that there's an overlap. Good reason to extend time, even if there's a third stage coming, in principle includes consideration of degree of prejudice. And this is the way we put it in our paragraph 23.4 to 23.6. So again, what I'll do is, if I may, is give you the position in principle as we submit it is, and then we'll look at some authorities. Why does the good reason to extend time in principle include the degree of prejudice? Because it's a point in the applicant's favour, the absence of prejudice. That's what any court considering a discretion to extend time would expect to be doing. One of the things you want to see is there prejudice? It can be a point in the applicant's favour, we say that at 26.8. It can make the difference. It can tip the balance in public interest terms. So what wouldn't have been a good reason to extend time otherwise can be a good reason to extend time, given that there is no prejudice. A case that would otherwise have been rejected can be accepted if this is included. Because it is extend time, not for delay. Good reason to extend time, not good reason for the delay. And because there is here an overall public interest balance, as we describe it in 34.3, of our printed case. This approach has two further advantages. I've touched on them both already, but I'll just remind you. Firstly, it is even-handed between the parties. Because just as leave can never be granted in a delay case without the respondent and third party being able to invoke the presence of prejudice, so too, leave can never be refused in a delay case without the applicant being able to invoke the absence of prejudice. And the second point already made, but I repeat, is that it respects all the rules, the statute and the civil procedure rules, and all the mandatory provisions in the rules, including 56.53. Can we look then at a practical example? And I'm going to show you if we go back to 2002 and the old Fishermen and Friends of the Sea case, which was decided in August 2002, for the paper followers, it's volume 1 of the authorities at tab 10, and in the electronic, on the screen, you'll find it at 618, page 618 of the bundle. Now, in my copy, although it was difficult to pick this up, there is actually a line on every single page that doesn't appear. In some it's very faint, and some it's completely absent. So we have got a hard copy for you, if you would prefer. It's been passed. I'm told it's been passed up. It looks like this. Yeah. It's just infuriating because you think it's not going to matter, and then you probably stumble across a page where it does, and I'm sorry about that.
Yes. Thank you.
I'm very sorry if that frustrated you, given that you've obviously spotted.
I'd be personally grateful if you could also send it to us in memory stick form or email or whatever.
Yes, can we do that? Yes, of course we'll do that. So I hope you've now got a printout, and we'll work from that. This was Justice Barrow, as he was, in 2002. We've now got a different problem because we've got no pagination, but if you go to the 5th page, you'll find a heading delay. And you then get...
Which E-page is that?
In the E-pages, my lord, it's the bottom of 626.
Thank you.
Or middle of 626. You, my lord, should have delay.
I do.
And then we get a section on delay. He sets out, they're not quite the same as the English rules, but they borrowed from them, and then section 11, and then line of authorities, Jackson and Caswell, and then a summary and 4 points. And the 4th point is this: if there's good reason shown for extending time, the court may grant an extension. Even if the court considers there's good reason, it may still refuse leave. The granting of the relief sought would be likely to cause hardship or prejudice or be detrimental to good administration. And then you will see, when he proceeds, electronic bottom of 629, rest of us top of the next page, to address delay, he does it under 3 headings. 629, or that page, whether good reason shown for extending the time. But then heading number 2, 632, next page, for the rest of us, whether detrimental to good administration or prejudicial to BPTT. And then 3rd section on 635, or penultimate page, for those with the new paper version, does the public interest require the application should be permitted to proceed? Now, if you just pause and ask, does the public interest require the application should be permitted to proceed? Is that going to be part of a public interest balance when you are deciding whether to give an extension of time? Answer plainly, yes. You couldn't have that issue raised before you and ignore it and refuse leave without considering it. But what the judge actually does in Fishermen and Friends of the Sea is deal with good reason leaving aside prejudice and leaving aside public interest and reach what's effectively a provisional conclusion or a minded to conclusion. even within the good reasons section, you'll see that item 6 is public interest, top of 630, middle of that page in the paper version. And that's the point that he then defers to a separate section. So the provisional conclusion, I will call it, or the minded to, the leaving aside conclusion, is the one just above heading number 2, bottom of 631, a third of the way, quarter of the way down, the page that starts with additional 4 weeks. In my judgment, no good reason has been put forward for the grant of an extension of time. Going on then to look at the questions of prejudice and detriment and hardship. On the penultimate page, top of 635, you get the conclusion in that section. In my judgment, there will be significant prejudice. And so on. This was gas pipelines. They'd already started work on the construction. And then you get the public interest, and you'll see reference to the very interesting decision on 635 under the heading 3, the very interesting decision of Morris KJ in Greenpeace, and I'll come to that.
The judge deals with all the issues he'd identified in the summary at whatever page it was, page 628, but he actually, at the end of the day, finds there's no good reason shown for extending time. And on his approach, he can stop the analysis there. At section 11.1 of the Judicial Review Act.
2 points. Firstly, what did he do in this case?
Well, I know he dealt with every aspect, as you'd expect a trial judge to do.
Well, in my submission, what he did in this case was reach a provisional conclusion that he then tested against the other issues. But there's a footnote, an important footnote to that submission, which I'm going to come to in a moment.
Yeah.
Park the submission. That's the first thing that he has done. Second point, could he have stopped at no good reason has been put forward to the extension of time? I therefore refuse to extend time, and that's the end of it. Answer, no. He couldn't have done that. He needed to test against these other matters. Firstly, because if there had been no hardship, prejudice or detriment, and you're a public interest case in relation to environmental law, it would make a difference. It would weigh in the balance, and you would be ignoring it. And secondly, because if he looks in his civil procedure rules, he will see that he has to consider it.
Well, the CPR may be beside the point. At the end of the day, the statute is the ruling text. And if there's an inconsistency, the Act, obviously, is what you give.
Yes, if the Act said that in a case of lack of promptness, you can extend time if you're satisfied that there's good reason for the delay. Suppose it said that. And the rule said something broader than that, you'd have an inconsistency. If the statute said, and in considering whether there is good reason to extend time, you shall not have regard to hardship, prejudice, or detriment, then you'd have an inconsistency. There's no inconsistency in our submission between the statute and the rules.
Now, the argument against you, I think, has two aspects to it. One is that the judge here understands himself to be following the approach in ex parte casual, and that's an approach under which he could have stopped at no good reason to extend. And the second aspect is, when the Privy Council come to look at this, they treat him as reaching a decision under 11.1 and approve his approach.
Well, let's look at that. Volume 1, tab 11, because this is my footnote, and I said it was an important one. If the board please goes to paragraph 27 on page 648, there is a heading, the judge's exercise of discretion. And the way it's actually put by the Privy Council is illuminating, we say, at the bottom of that page. And what's said for the board by Lord Walker is, as their lordships read his judgment, he expressed a definite preliminary view against granting an extension of time because of the unjustifiable delay on the part of fishermen and friends of the sea. But then went on to test that conclusion against other issues, including the public interest and the strengths and weaknesses of the case. His consideration of those other matters did not alter his preliminary view. On the contrary, they confirmed his view that an extension should not be granted. So I've submitted to you that it was provisional and it was looked at in the round. But what really matters is that there's no endorsement for anything other than that, because that's how the Privy Council saw it. And let's forget hardship for a moment and take the public interest. Suppose the submission is, well, there's been delay, but there is an issue of importance and the public interest calls for an extension of time. If what my Lord has put to me were right, then Justice Barrow, as he was, could have stopped and not gone to his third section either. I'm applauding him here because I say he took into account, he did the right thing, he looked at the relevant considerations. And as I say, suppose those second and third topics had gone the other way. Suppose topic 2 had come to the conclusion there's absolutely no prejudice here. Suppose topic 3 had come to the conclusion there is a strong public interest in this case going ahead. The idea that you would stop and look at good reason to extend time in isolation, we say can't be justified.
But won't a strong public interest in having the point determined at a full hearing of itself be a potentially good reason for extending time?
Would it be? Yes, it would.
So why can't I'm slightly puzzled by the way the first instance judge, again Judge Barrow, dealt with it in Fishermen Friends, because he lifted public interest out and put it at the end,
yes,
rather than putting it in at the beginning when considering whether there was a good reason to grant an extension of time. And if he'd found that wasn't a good reason either, so far as I can see, he could have closed his book at that point, because the hardship, prejudice and detriment considerations would only be considerations which made the applicant's position worse if there were any.
Yes, quite. So you say, a judge can always do this, whether because of the state of the evidence or because it's the analytical process that's most attractive in case managing the case. Assume no hardship, prejudice or detriment. Is there a good reason to extend time? And then once considered it, one doesn't need to get into it unless the respondent, the third party, is saying, well, wait a minute, we've got section 11.2, you must get into it. But what you can't do is hive it off. And it may be that the headings were because of the way he'd read Caswell and Jackson. But what's interesting, the proof of the pudding point, is what he actually does, and then what the Privy Council makes of it. You've got the point, you can test it. It's a very good way to test it. Could he really have stopped? And what if those other topics had gone the other way? And if you wouldn't strip out the public interest, why are you stripping out the degree of prejudice? But that's what the Privy Council made of it. And
the way the Privy Council seem to view it is that you have to show, if your application hasn't been made promptly or within 3 months in any event, you have to obtain an extension, and therefore you have to show good reason for an extension. But as you say, looking at the discussion of Justice Barrow's judgment suggests that under one, a provisional view is reached that there's no good reason for an extension. And then under 2, other factors are considered in the light of which that provisional conclusion might be confirmed or departed from.
Well, they're not saying that's the way to do it. What they're saying is that's a legitimate way to do it. What they say at 32 on page 650 is that there was no flaw in approaching it in that way. Now, it's worth having in mind that not only has Justice Barrot in that case talked about the interesting decision of Mr. Justice Maurice Kay as he was in Greenpeace, but the Privy Council referred to it on page 647, paragraph 25, where the judge had referred to it. And I would like to go to it because it's a brilliant practical example, albeit it is a comparative case. You've seen that it is folded into the thinking in Trinidad and Tobago. And so, therefore, can we please look at it? It's in volume 2, tab 29, and it's at page 1052. This was in the middle of the then Mr. Justice Maurice Kay's High Court tenure, but he had not yet become head of the Administrative Court. That was a role he had a couple of years later. But this is his judgment in Greenpeace number 2. And you'll see what he does from the holding on the first page, 1052. He grants, it's a rolled-up hearing, so he has to deal with leave. He grants permission, and he grants a declaration that there's been a breach because the British government have misappreciated the reach of the EU Habitats Directive protections. That's what the case is about. The rules are described in the judgment at 1075, the English rules, at 1075 in the middle of that page. You'll see you've got the A and B that I was describing to my Lord Lloyd Jones in the English provisions. So those are the equivalents then of the section 11.1 and section 11.2 in Trinidad and Tobago. At the bottom of 1076, he encounters what had been said in an earlier case by Mr. Justice Laws, which some of you know all about because you had this in Fishermen and Friends of the Sea this year. Is it harsher for a public interest claimant? Mr. Justice Laws had indicated that it was. Mr. Justice Maurice Kay didn't agree with that. He deals with it at 1080. Having said, paragraph 3, 8 lines down from the top of 1080, the requirement of promptness is accentuated when third-party interests are involved. Now, just pausing there, can I just make a point there and link it to our paragraph 17? That's absolutely right. There's good authority for it.
I'm still struggling to find it on page 1080.
Yeah, 1080, about 8 lines down, paragraph 3, the requirement of promptness.
Oh, I've got it, yeah.
Do you have that, my lord?
Yes.
So what that tells you straight away is that even on question 1, is there relevant delay? You're already into, are there third parties affected? Because that's precisely when an applicant will be told 3 months is too late. Because people were signing contracts, they were going to be spending money, they were going to start building pipelines. And the references are 1043 at the bottom, 978 at the top. 1043 at the bottom is TVNI 227 at the bottom. 978 at the top is a case called Hay, Mr. Justice Sedley, volume 2, tab 22. And in our printed case, it's paragraph 17. It's all set out. Absolutely right, but it's very revealing because not only are you already reading section 11.1 with section 11.2, because promptness, lack of promptness and undue delay are synonyms, so you have to merge them, you read them together, but you are already bringing in the public interest implications of whether others are affected. The idea that you have it in at stage 1, then out at stage 2, and back in at stage 3, which you may never meet, is, with the greatest of respect, we say, impossible to justify. Back to Mr. Justice Maurice Kay. Middle of that page, I cannot envisage many cases where you'd be thrown out as a public interest claimant. So he doesn't think much of that, nor did this board earlier this year.
Sorry, where is that?
It's right in the middle of the page. The line starts with the word part, and it's 3 lines above paragraph 4.
Yes, thank you.
So beware of strictness in the public interest litigant. Then we're getting to the nub, because if you go to page 1081, he says halfway down that page, the line begins requirement of promptness. In that sentence, I'm driven to the conclusion they've not satisfied the requirement of promptness in this regard. So, question 1, is there relevant delay? Yes. Then it's paragraph 6, numbered paragraph 6, 2/3 of the way down. I therefore have to consider whether this is an appropriate case for extending time. In applying Order 53, Section 31, as analysed in cases like Caswell and Jackson, the material questions are those posed by Laws J in the Greenpeace No. 1 case. I adopt them as subheadings here, and then 3 headings answering that question. And actually, if you think to Trinidad and Justice Barrot, is there a reasonable objective excuse for applying late? Question number 1. What, if any, is the damage in terms of hardship, prejudice and detriment is question number 2. Question number 3, middle of 1082. In any event, does the public interest require the application should be permitted to proceed? And those are, this time it's not a minded to decision and a cross-check and then a final decision. It's actually roll it together to decide whether to extend time.
But he's adopting a quite different good reason test. He's not saying, is there a good reason for the extension? He's saying, is there a good reason for having...
That is true, although actually
and
Justice...
I thought your case was, and I'm not even sure it's seriously in dispute, that that's not the right approach to
Correct.
good reason in any case in Trinidad.
Correct. My Lord's observation is right. Subject to that tweak, and it's correct, his second topic...
It's hardly a tweak.
Justice Barrot focuses on reason for delay plus in his first section. Mr. Justice Morris Kay focuses on only reason for delay in his first section. So I withdraw tweak. It's a material difference. The point I'm making is he then has, as a second heading within the good reason to extend time, the very second heading that we had in Justice Barrot, hardship, prejudice and detriment. And we then have a third heading, does the public interest require, which also reflects heading number 3 of Justice Barrot and the Privy Council. And what he's done, and it's well established because he's following earlier authority, is identifying 3 features of the material questions. Now, to go back to the difference on topic number 1, suppose he had said, is there a good reason to extend time, leaving aside prejudice and public interest to which I will return? Then you'd have a direct parallel. But the point would be the same. All of these considerations feature, as they must, in coming to the overall public interest conclusion. And the reason why Greenpeace is such a brilliant example is because he's not satisfied at stage 1. In my judgment, there is not a reasonable objective excuse for their failure. 2/3 of the way down, 1081. It's only because of what's coming next that he's persuaded to extend time. So what, if any, is the damage that would be occasioned? And he discusses it. And it's also quite a good example because it's a case where the relief had been quite carefully crafted so that it wasn't going to reopen licences already granted. If you see that at 1082, at the end of the first complete paragraph on 1082, Greenpeace won't seek to reopen early licences. Others might try, but they wouldn't be able to. It would be too late. Next paragraph, what is it going to mean? It's going to mean the government's going to have to apply the law. Now, that might delay their decisions on licensing, but they'll still be able to make decisions on licensing. That's the "it is also important" paragraph. And then the public interest he says there is strong public interest and he has regard to the merits.
But isn't this sort of way of doing it really a consequence of being embedded in the old rules of the Supreme Court, where if somebody wanted to get an extension of time for something, you asked, had he got a good excuse for his failure? But sometimes, even if he hadn't, if there was no prejudice caused to the other side, you still gave him the extension. And that's the private law position under the rules of the Supreme Court, and then you graft on the public law question at the end, because it's a public law application. It seems to me that's already that already grows out of an old and actually now discredited and replaced approach which our rules of court always used to take to these issues.
Yes, start with have you got a good excuse, and then second
And if not, that's not the end of it if you haven't, because you may show that the absence of prejudice still means it ought to be done, so that there's a fair trial of all the issues everybody wants to raise. For example, if what you're trying to do is amend a pleading. Now, that was deeply ingrained in most judicial minds until it was done away with in the Jackson reforms.
What's applicable in the public law world is that you already have a broader question, because the rule is not a good reason for delay.
Absolutely.
And once you've opened that up, then the thing that is obvious elsewhere is really important, not least because judicial review is the rule of law in action. We're talking here about unlawful actions of public authorities. I'm going to show you Burkett because there's a helpful passage on that. But for illustrative purposes, two things. Firstly, here is a principled approach in a jurisdiction that applies Caswell and Jackson, that recognises that topics like degree of prejudice and topics like public interest are necessarily woven into the good reason to extend time. That's the whole point. This is public law. And second reason why this is a good illustration is that if I'm wrong and you dismiss our appeal, in Trinidad, this case would stop before you get to Roman 2. Because the judge will be able to say, I don't have to get into that. That's a stage 3 point. And so the implications are striking. Precisely because the absence of prejudice can be such a powerful point for an applicant. And you wouldn't even be able to say, wait a minute, Judge, we've designed our relief in this case so that there's no prospect of prejudice. Sometimes applicants in judicial review will only seek a declaration. And we've got a case in the bundle about that, about a school admissions policy that was an ongoing breach, and the court was concerned. It's called Polymore. And it discusses two earlier cases that make the point that delay may not justify refusing leave, but may affect the relief you can seek. So I go into court, I say, here's the relief that we've designed, and the judge in Trinidad says, well, I'm not going to hear you about that, because that's all to do with prejudice. And I'm not interested in prejudice because I'm at the good reason stage. And it's only if you can satisfy me on the good reason that we'll reach all of that. The other reference point, just for the board to have, and it will be ringingly new to, I think, 3 of you, is Fishermen Friends of the Sea earlier this year, Volume 1, Tab 13.
Can I ask, are you going to take us to Caswell?
Well, we can go back to it. We've seen it cited. It was summarised by Justice Barrow, and it was summarised by the board.
At the moment,
If my lord wants to go to Caswell, we'll go to Caswell.
yes, I do. I mean, at the moment, I think we're in danger of confusing two things. One is what you've called the route to judgment is. In other words, what are the questions you have to be asking yourself, and at what stage can you reach a final decision? And the second matter is what factors are relevant to the assessment at the different stages.
Yeah, well, you're right, because that's the difference between my overlap point and my fusion point.
Yes.
But you've got my submission, which is that even if it's overlap, that's enough for me. But let's look at Caswell. It's Volume 1, Tab 8.
And it's perhaps useful to begin with the quotation from, or the discussion of Jackson at page 590.
In Caswell?
Yeah.
Yes, my lord. Both Jackson and Caswell were about what was available at the substantive stage in the judicial review. And you'll see the key to that on letter E on page 590.
Well, before we get to E, can we just see what it was about perhaps at D?
Certainly, my lord.
So the argument was that where good reason had been held to exist for the failure to act promptly, and therefore an extension had been granted, then there was no power to refuse either leave or substantive relief.
That's right.
On the ground of undue delay, because the extension negatived the existence of undue delay, and that submission was rejected.
Correct. And just to see how corrosive that would have been, if you look at the previous page, at letter C, you'll find section 31. And 31.6b is relief. Mm-hmm. So I'm at the substantive judicial review. I say hardship, prejudice or detriment to good administration. Applicant says you can't rely on it. Why? Because time was extended by the leave judge, which negatives the undue delay. There is no undue delay. If I got an extension of time, the judge was forgiving my undue delay. Yeah. That's why I say that's what these cases were about. Jackson was about deferring it to the substantive stage. Caswell was about being at the substantive stage. Hmm. And so the English provision that includes the relief stage is recognised, and I accept this, as identifying, firstly, a distinct strand, hardship, prejudice or detriment, which alone is available at the substantive stage. And secondly, it's identifying the fact that that really is available at the substantive stage because it's not negatived by the extension of time and grant of permission. And it is important to see that that was the context.
And that's all because, isn't it, in those days, the concept of giving an extension of time depended on whether you had a good excuse for the delay, not whether there was a good reason for the extension. And that's implicit, it seems to me, in this treatment, because yet again we see references to good reason for... Well, good reason had been held to exist for the failure to act promptly, as required by Order 52, Rule 4.1.
Well, that, with respect, is wrong and always was wrong. Because if you look at the top of 745, the rule was good reason... So, my lord... Oh, so, I'm so sorry. I'm so sorry. I'm in the law report. Yeah. 589. I do apologise. You see what the JR rule actually was? It's a trap that people fall into all the time. Good reason for delay. No. Good reason for extending the period.
Yes.
That was always the rule. Well, and Lord Gough gets it back at the bottom of 590 and the top of 591.
Yes.
Now, I accept that in that context, the House of Lords strips out, treats separately, the two issues.
Yeah.
But it's in that context for good reason. And in fact...
It's not... You can't confine it to the stage of substantive relief. It's also... It deals with both, doesn't it?
No, I accept that too. It says, even if there's a good reason to extend time, you can still refuse leave for judicial review.
Yes.
So
the critical passage, I think, is probably on 591, starting just below letter B. It follows that where an application for leave to apply is not made promptly and in any event within 3 months, the court may refuse leave on the ground of delay unless it considers that there is good reason for extending the period. But even if it considers that there is such good reason, it may still refuse leave if, in its opinion, the granting of relief sought would be likely to cause hardship, etc. So far we haven't been... This discussion isn't dealing with what the relevant factors are, but it's telling us you can reach a decision at the stage of what's Section 11.1 in the Trinidadian legislation. And if that decision is in favour of the applicant, there may nevertheless be a refusal under 2.
Right.
Right. So what then becomes a critical factor really is what factors are relevant to deciding whether there is good reason under 1, and that's where the discretion given to the court under subsection 3 comes in.
Right, so my response. The House of Lords is not saying that you look at good reason to extend time independently of hardship, prejudice or detriment. They don't say that. If that were right, Greenpeace would be wrong. Be wrongly decided. It would be inconsistent with Caswell. What Caswell is saying is that the leave stage, even if the applicant has pointed to what would otherwise be a good reason to extend time, you can still refuse leave if there's hardship, prejudice or detriment. They don't analyse whether a judge would sensibly look at those in the round, and they certainly don't say that a leave judge could extend the time for judicial review and then in the next breath refuse leave for delay. They don't say that the absence of hardship, prejudice or detriment is irrelevant to the good reason to extend time as a point in the applicant's favour. They don't say, as Justice Barrot does, as I've just explained, here's your route, and at the second stage you give the extension of time, but you then refuse leave for delay. They're not, with respect, grappling with whether it's sensible to look at the leave issues in a composite way, albeit that you might start by putting hardship, prejudice and detriment to one side. And the reason for the distinction, and it's so important in England and Wales, is because you have to see a distinction between the hardship, prejudice and detriment theme or issue, because that's not only what you can use at the substantive hearing as a respondent or third party, it is all you can use at the substantive hearing as an interested party. Caswell is the case in the House of Lords that says it's still open to you because you haven't negatived the undue delay through the extension of time. And that's really what Caswell decides. And there's a case called A and the Criminal Injuries Compensation Board that's in your bundles, which takes it further and says once you've got to the substantive stage, not only is it open to a respondent or third party to invoke hardship, prejudice or detriment, but that's all they've got. That's the only issue that the court will consider. But my submission is there's nothing inconsistent between this and a principled approach that asks a composite question at the leave stage. But even if there were, then I fall back on my factors, which is my Lord reads other way. And I say, suppose you're going to keep 3 questions then. It's a rather bizarre thing to do, but suppose you're going to keep 3 questions. At stage 2, you've got to bring it in, as Mr. Justice Morris Kay did. Why do I say it's a bizarre thing to do? Because if you're going to bring it in for promptness and you're going to bring it in for good reason to extend time, why on earth do you hold it back for separate consideration on the same day in the next paragraph of the same ruling? And why on earth would you want to tell an applicant, I've just given you good reason to extend time, good news, you're within time for the purposes of leave, but by the way, I'm now going to refuse leave because of delay, by reference to a factor that I've just considered in relation to the good reason to extend time. And that's where you're driven. And Caswell doesn't go within a mile of that in our submission. I hope that was helpful, my lords. That's what we say about it. Can I come back up to date? Then?
I suppose, I wonder if one could take a little bit further and say that in section 11.1, the critical question, apart from promptitude, the critical question is whether there is good reason for an extension. And it's a very open-ended question, that, and therefore the range of matters which a court might consider relevant in in terms of subsection 3 might be quite wide and could include, for example, the public interest. When we're looking at 2, the factors that have to be taken into account are we're told what they are. They're prescribed by the subsection. Substantial hardship, prejudice, good administration, detriment to good administration. And so the matters that could be taken into account under 3 would have to be matters that were germane to those specified factors.
I wouldn't accept that. And this supports the holistic approach, because even if you conclude that relief would cause substantial detriment to good administration, there's no duty to refuse leave. It's a discretion, and therefore the court has to say, is it justified to refuse leave in this case?
Yes, I see.
By reference to the hardship, prejudice, or detriment.
Yeah.
And at that point, you couldn't possibly leave out of account the fact you've just said it's in the public interest for the case to proceed, or you've just found that the person was ignorant for 6 months because the public authority had failed to disclose that they'd reached a decision. So I go this far. I say, yes, it's very helpful that it shows that one has to look at the factors together, but it does then press on to the integrated consideration of what are necessarily interlinked issues.
Just before we leave Caswell.
Yes, my lord.
Lord Gough is heavily influenced, if one looks at page 591, halfway between letters C and D and down to the end of the paragraph, in thinking that it might well be sensible to look at good reason to extend before looking at questions of hardship, prejudice and detriment.
Yes, ma'am.
Because generally speaking, the application for leave, including if necessary an extension of time if made late, would be made ex parte.
Yes.
Now, I've just been looking at your rules, which also contemplate that in the ordinary course the application for leave is made without notice, or may be made without notice, and determined without any communication to the other side. So, but, of course, the court can direct that the matter be notified to the other side and dealt with in open court on an inter partes hearing. That's all Rules 6 onwards. I just wondered whether the same logic that Lord Gough is talking about doesn't apply in your procedural situation. Now, I know that in this case, for rather unusual reasons, the application for leave and an extension of time was all rolled into an inter partes hearing. But we're asking how these rules can be allowed by judges to work in the whole panoply of situations, including the ordinary one, where the applicant comes ex parte. Where the judge could, it seems to me, say, well, if there's a good reason, I'll grant permission, and then and an extension. The other side can either come back and ask that to be reconsidered in an inter partes hearing, which I imagine your rules permit, or it can be looked at again on the question of prejudice and delay at the final hearing.
Quite so. And in that, take that situation, my answer is the one I gave earlier. There is nothing wrong at all. It would be perfectly proper for the judge to say, I will assume in your favour there is no hardship, prejudice or detriment. You're telling me there isn't any, but I haven't got evidence from the other side at this stage. If they want to adduce it, they can. They've got at least, in fact, they've already had an opportunity because there is a pre-action protocol in our jurisdiction in Trinidad, and so actually they have already had an opportunity to say.
Hasn't followed through into the rules yet, but okay, yes.
There is, and if you think about it, my lord, you'd have similar issues about promptness. How are you going to approach promptness? I'm within 3 months. You're dealing with my application for leave. First of all, I've got a duty of candour, so I have to disclose things that are against me. You have to decide, do I think this is sufficiently prompt? And so the answer is the court will address the issues on the evidence it has. Pre-action correspondence, candour from the claimant, what it's told by the claimant. But there's no harm done, and you could assume something you're not in a position to decide otherwise. What you can't do is shut out on the basis of something because you're at the ex parte stage. So I accept it's relevant. I accept it's relevant in practice to what the court's approach will be. What you have to do is give due consideration to the issue. It will be the same for promptness. Are there third-party interests involved? Well, I can't really know for sure, but here's what it appears on the face of it. It will be the same for lack of knowledge. Section 11, subsection 3. You have to have regard to when the claimant first got to know. You're dealing with the papers, you're the judge, you're not told that. So it will be the case with a number of issues. You decide it on the evidence that you've got. What you can't do is shut it out and refuse leave. Unless there are further tricky questions for now, can I come back to the board earlier this year in Fishermen and Friends of the Sea? It is in volume 1 at tab 13 in the paper of the authorities, and it's at bundle 691 in the electronic. I'll take it lightly because you weren't deciding the issue. The board wasn't deciding it, it was leaving it open, as I've already said. But I'll just show you what you get from it. Paragraph 22 on page 700. Lord Carnworth for the board deals with the delay provisions at the top of the page. Then at 22 explains that the Act must prevail over the rules if there's an inconsistency. I've accepted that, but there is none. Middle of 22. Important duty to act promptly regardless of 3 months. Accept that. And then this, it seems also that the purpose of the specific limit is to provide a degree of certainty to those affected accordingly that strong reasons are needed to justify extending time where other interests, public or private, are involved.
Sorry, where are you reading?
Bottom of 700, four lines from the bottom.
Thank you.
Quite so. That illustrates that you will want to know as the judge, are there other interests involved so that you can decide whether there are grounds to extend time. And that, like the promptness issue, will necessarily take you into, is there hardship, prejudice and detriment? Then there's a reference to 2005 Fishermen and Friends. Then we get Barrow's 3 stages at 23, Justice of Appeal Barrow. Then you get the issue that's before you today at 24, not going to resolve it on the present appeal, but where the proceedings would result in delay to a project of public importance, then a strict approach. Well, same point, strict approach to extending time because you are in a context where you have got a project that you're going to be delaying. You don't need specific prejudice or hardship to particular parties. Accept that. Hardship, prejudice and detriment doesn't necessarily need specific evidence to a particular party. No such competing public interest in Abzal Mohammed. That's an interesting point. So that's a case which I'll show you in a minute, where there wasn't anything cutting against the judicial review applicant, so you can count the absence of prejudice in his favour. Exactly the same is true in this case. And then it's accepted that there may be overlap between 1 and 2, so that you look at various things, including any prejudice in the overall balance. Well, that's the overlap point.
I think you would say, Mr. Fordham, that it should be taken into account.
I would say there is, but I would go further and say, actually, it's a holistic question. If you're the lead judge, you really only need to look at it once and in the round.
Must be taken into account.
Yes, it must.
Not may be taken into account.
Correct. And then at 31, you had the older Greenpeace case. I say you, those of you who were on the board. So you would have had the 3 headings that Mrs. Justice Kay then applied in the later Greenpeace. So you've got our submissions. You know I've got 2 ways of putting it, and I've explained them, and I've shown you the authorities. I am bold enough to go for the fusion approach because I say that it reads 11.1 and 2 together. It's supported by 56.5.3, which is not an unlawful rule because there's no inconsistency. And it makes sense because it avoids the oddity I've now described at least 3 times. Grant extension of time in one breath, refuse leave for delay in the next breath. There's just no need to do that. But yes, there is a distinct question. We saw it in Caswell, who then follows through into the case of A for the relief stage.
Is there a risk that taking that approach so far that it must be done in every case means that it's going to be very difficult for judges to decide these applications on an ex parte basis, leaving it to the other side to come back if they want, or to raise the issue of prejudice at the final hearing? I mean, I have in mind that as Lord Gough said, and it must be right, you really need the other side to be there to get a grip on any question of prejudice, hardship or detriment. You can't assume just because they haven't raised it that there isn't any if they're not there.
My response. First of all, the choice you're making is to whether to dismiss the case or allow it to continue. So it's very stark. Secondly, you could approach it by saying, even if there were prejudice, hardship or detriment, I would be satisfied that you've got a good reason, because it's in the public interest, such an important point. You could defer it, which is frequently done, it's a power that's open to you. You could say, on the face of it, I can't see any hardship, prejudice or detriment, and you're obliged to disclose anything you're aware of, and I've read the correspondence. You could say, I'm going to proceed on that basis. I have regard to the absence of prejudice in your favour, but they can apply to set aside and they can raise it at the substantive hearing. So there's no procedural prejudice. But whichever way you cut it, my lord, in my submission, there's no improper burden on the judge in that situation. And the contrary position operates against the public interest, because what it will mean, necessarily in logic, is that cases will be refused leave where, if regard was given to the absence of prejudice, they would be given leave, and that can't be right. So there has to be a route. Yes, that's right. This was one of Justice of Appeal Smith's objections, and I'm reminded that we set out a whole load of reasons to deal with it at the bottom of page 300 in our printed case at paragraph 35. I'm conscious of the time, and I did want to show you some further authority, and I have got some further points also that I need to deal with. If you bear with me, can I commend to you Absal Muhammad, which I haven't even mentioned yet. This was the Court of Appeal unanimous decision at volume 1, tab 5, which determined this issue. And you've seen the letter that was sent. It was settled.
What's the page?
Page 468.
Thank you.
So, unanimous Court of Appeal at 468. I'm not sure I now have the time, it's my fault, nobody else's, to take you through it in detail, but can I commend it to you, because the Court of Appeal is there deciding, first of all, paragraph 15, that there's no threshold condition of explanation for the delay. That takes me back to my exchange with my Lord Briggs about the difference between explanation of the delay, top of 473, and good reason to extend time. And just to walk you through it, but I invite you, if I may, to read it. Paragraph 16 cites Lord Wolfing-Croydon. Lord Wolfing-Croydon is saying, if you've behaved sensibly and reasonably, and there is a lack of prejudice, then it's appropriate for the case to proceed. That only works if you can bring in the lack of prejudice.
Mr. Fordham, I think in a sense that this authority may go further than your submission.
Yes, it does. And
because it seems to be saying that it's only if there is prejudice that the court can refuse to grant leave.
Yes,
and you get that at paragraph 21.
Yes, that is correct. That is not my position, and that was qualified correctly in the dissent of Justice of Appeal Jamadar in the present case. So he said it may have been overstating it, if and insofar as this means never. And I accept that. But they're certainly right to say, in principle, absent hardship, prejudice or detriment, the case should proceed. There was an important qualifier. If you look at paragraph, let's look at 19 first, if we can, at 474. Justice of Appeal Kangaloo for the Court of Appeal, third of the way down that page, having cited Argyll, a compelling reason may very well be the lack of prejudice.
Sorry, where are you reading?
474, paragraph 19, just after the quote.
Thank you.
So that's making the point that it's a reason in the applicant's favour that there is a lack of prejudice, same thing that Lord Wolford said on the previous page in the quote from Croydon. Then we get paragraph 20, don't deprive the applicant of leave, absent hardship, prejudice or detriment, at least if the delay is short. And that's the qualifier, a fortiori at the end of paragraph 20, top of 475. Then we get the rules, read them together, and my Lord Lloyd-Jones is right. The end of 22, delay alone not the deciding factor as to whether to refuse leave, but that's not the deciding factor. 25 is spot on page 477 in our submission. The question of what amounts to a good reason, all these factors, among the factors to be taken account are, and D, in paragraph 25 on page 477, degree of prejudice. Now, whether it's a composite question, fusion, or whether it's an overlapping question, in principle, degree of prejudice is a factor to be taken into account, says the Court of Appeal. And they are correct. And then the approach at 26 to the present case. The delay was short. The reason for the delay was plausible, although it may not amount to a good reason. Didn't sleep on his rights, actively attempting to get the Commission to revisit. No prejudice or detriment has been demonstrated, nor is any self-evident. Back to the judge deciding it on the evidence. Court can say at the ex parte stage, on the basis of what I've got, there is none, and I take that into account in the applicant's favour. And then at the end of 26, you get the recognition that we're not talking about good reason for delay. Was it per incuriam? No. It's not inconsistent with Fishermen and Friends of the Sea and the Privy Council. We looked at that. I showed you what the board said about Justice Barrot's approach, and you've seen that it did take account of those factors.
Might it not be said that it is per incuriam because it goes beyond that by reaching a position in which, in the absence of prejudice, leave has to be granted?
Well, that doesn't make it per incuriam. It might make it wrong if it were appealed to this court. But for the purposes of today, my submission to you is that Justice of Appeal Jamadar's dissent in the present case is the correct position in the law. And he deals with this point expressly. Had there been a sequel to Abzal Muhammad, in which the controversy between the parties had been, is it really the case that it's automatically I'll get leave if there's no prejudice? The submission would have been, well, that's not actually what the Court of Appeal decided, because they emphasised when the delay is short. But insofar as what it's what the Court of Appeal decided, then that could have been contested.
Sorry, please do. It does seem to be part of the ratio that in the absence of prejudice, there had to be an extension of time.
To which I would add, in principle. And I maintain that position. That's the position we take in our printed case. Yes, in principle, that's right. Now, can I just give you, at speed, the cases in our paragraph 11. They're in our printed case at electronic page 276 and 277. I've already done Greenpeace, but I've got one further comparative example. There are loads of examples called Castle in 11.2. How did the Divisional Court approach the extension of time? And the very first point they make, no prejudice is identified. And then two cases from Trinidad, 11.3 and 11.4, B and the Children's Authority, where Mr. Justice Corcoran says, and you'll find this at page 575 of the bundle, Authorities 1 tab 7, the question of prejudice and detriment to good administration must be taken into account in the exercise of discretion to extend time to apply for leave. That's exactly right.
These are all first instance decisions.
They are all first instance. And Mr. Justice Rampasad in Charles is another good example, taking all the circumstances into account and the lack of an objection or evidence of prejudice in regard. They're all working examples. Now, my lords, my lady, there is not a single case in this bundle, and I add that I'm aware of, I would have brought it, that extends time on the basis of a good reason to extend time, but then refuses leave for reasons of hardship, prejudice and detriment. You can understand why. You wouldn't do that either if you were the single judge. Why would you do that? What you would do is you'd say, is there a good reason to extend time? And I'm going to consider everything I've been told, and I'm going to have regard to all the factors. There wouldn't be anything left. The closest we come, there's a case called Eurotunnel. And if I had longer, I would take you to it. It's quite fascinating. It's Authorities 2, tab 26. We deal with it at paragraph 36.8. Where in England, the court runs the exercise twice. They do good reason to extend time incorporating hardship, prejudice or detriment, and they then do hardship, prejudice or detriment again, but they approach it in a slightly different way. So it's right that I make the court aware of that case. It's volume 2, tab 26, but it rather makes the point of how striking it is. Page 1033 in tab 26 of volume 2 is where you get delay, are there good reasons to extend the period? And all the familiar references, including Croydon. And then on 10034, in that context...
Sorry, where are you?
1034.
1034, thank you.
Just after the quote, in the fourth paragraph on that page, my lords, have the evidence and the submissions, I mean the second line of the quote, of the paragraph begins, while in this case.
Sorry, you're going to have to help me. Page
While in this case, page 1034.
Yes, while in this case, thank you.
The evidence by and submissions made on behalf of the objectors persuade us that to extend the period now could cause severe prejudice to the objectors and other persons. That's in the context of good reason to extend time. And they do all of that and say there's not good reasons to extend time, top of page 1036, but they've considered prejudice and hardship. And they then consider it again in the next heading at 1036. And here they're looking at prejudice from the relief. So the way they reconcile it is, we will look at prejudice for the good reason to extend time, but it's prejudice related to the delay. Now we'll look at it again in relation to a further stage, and it's prejudice from the relief. So I show you that. I don't defend that. I don't say that that's a necessary approach. But even on that basis, it reinforces the fact that we're right because they've considered it in relation to the good reason to extend time. Justice of Appeal Jamadar's dissenting judgment is right in our submission, and he doesn't put a foot wrong. He starts correctly at page 170 in the bundle by recognising the rule of law implications. He's at page 170. Vindicating the rule of law on 174, the importance of rule 56.53 at the bottom of 175. The importance, top of 180, of due consideration of the 11.2 factors. And then his qualification, my Lord, Lord Jones was asking me about this, paragraph 29 in the third line. Generally, I said in principle, ought not generally to deprive a meritorious application for a proceeding. He goes on to explain why it's a holistic question, page 184. Uh, 46, emphasising it's the good reason to extend time. 48, the holistic interpretation on 185 and the broader range of considerations. And then again the qualification at 51 on 186 about how Abs al-Muhammad is to be understood. There must be undue delay as well as due consideration of hardship or prejudice or detriment before leave can be refused or set aside. It may very well be that Kangaloo JA overstated the position somewhat, but my understanding is that they must at least be due consideration. That takes me back to what I would have said if I were defending Abs al-Muhammad. I think that's correct. That is what it was saying. But in any event, I'm defending this dissent. It goes on to say Abs al-Muhammad was binding and there's no reason why they shouldn't have followed it. That's what they should have done. I promised you Burkett.
So here's, I'm just trying to understand what the difference is between them. The majority accept accept the analysis in the policeman case, Abs al-Muhammad. They accept that analysis, paragraph 25, of what amounts to a good reason, and the whole range of factors, public interest, prejudice, and so on and so forth. But their approach is to look at 11.1 as first stage, and then if you get to it, 11.2. And under 11.1, they say in this case, the judge wasn't asked to, it was an inter partes hearing, he's not asked to consider, there's no suggestion of prejudice, the issue just isn't raised. He's asked to consider particular issues, he does, he reaches a decision, that's upheld. Whereas the dissenting opinion is adopting your fused approach, where you look at 11.1 and 11.2 together, and the decision is taken on the basis of both of them. And the judge seems to think that there's a duty to consider issues such as prejudice, even if they're not raised by the parties.
Well, first of all, the majority approach can be relevant, and I say wrong, is in principle relevant. Secondly, my Lord is wrong with respect to say that the issue hadn't been raised. The absence of prejudice was relied on at the oral hearing by the applicant and should have counted in the applicant's favour. There was an oral inter partes hearing.
Well, it may not be. Well, if I'm wrong, it may be the majority judgment's wrong. That's what they say. Looking at paragraph 29. Important to remember that in this case, the parties had agreed that the only factors the judge considered were delay and costs.
Yes, but the delay issue is all aspects of the delay issue. It includes the extension of time. That's where the judge had gone off the rail.
So, and they go on, having thus decided the matters that the parties had agreed to submit to him for consideration, he wasn't bound to go on to consider detriment and prejudice as further grounds for refusing leave. Right,
but that's because they say that's a residual discretion, and you've already failed at stage 2. You haven't showed a good reason to extend time.
Okay.
Can you just help me? The majority in the Court of Appeal took the view that although the judge expressed the good reason test as a good reason for the delay, he must have found that there was, in fact, no good reason for granting the extension. I'm puzzling as to what you say the good reason to grant the extension was in a case where the issue that the court would have had to grapple with at a substantive hearing if permission was given had already been, by agreement between the parties, resolved by another route.
Because we establish that the respondent has acted unlawfully and we get the document. They're resisting our judicial review and saying you don't get to any finding that we've acted unlawfully in this case because they're too late to bring it. So the issue of delay was being relied on for a substantive reason. It was to block us. Not just in relation to costs. It was to block us. They accepted if we could get through the gate of delay, then they hadn't got a leg to stand on.
Mm.
Can I tell you what I had left, and then we can decide what to do about time, because it's time for my left. I have the Burkett point, which is the House of Lords reminding us that we're talking about depriving a right to challenge an abuse of power, and that's relevant when you are interpreting and implying a procedural rule about delay. They also say, keep it simple. That's paragraphs 45 and 46 of Burkett on page 880. There's also an interesting discussion about Scotland, about how prejudice is very important when one's looking at delay in Scotland. And then finally, there are the other issues, which I will just rattle through. This is a classic no prejudice case. Freedom of information. The only harm is to our client here from the delay. He's got a statutory entitlement to the document they hold. They've claimed an exemption. They're wrong about it. It's even stronger than Abs al-Muhammad. It was 5 months, 10 weeks of which was pursuing a route to the Ombudsman properly. We'd written a letter before claim before the 3 months were up. And when the 3 months came up, we were still awaiting a response. It took them 5 weeks to respond. And when they did respond, they raised several alternatives to judicial review. And they threatened us with costs if we were to launch judicial review prematurely. Those discussions went on with those threats and warnings. We're trying to avoid litigation. And the first time they said they would take a delay point was on the 13th of January of 2010, and we filed 7 days later. And if you just read paragraph 21 of their printed case, it is breathtaking. 322 and 323 of the bundle. They say, all of this inordinate delay, when we had warned you that we would be taking a delay point. No, you hadn't, because back in your printed case on page 311, paragraph 4, the first time you raised that was 13th of January, 7 days before we filed. It's paragraph 21, and then you need to read back to paragraph 4, pages 322, 323, and 311, all with warnings about costs orders. You see the position as it was by the time it reached the judge. He was shutting out a case where we previously got leave, where there was by now a known error of law, and the substantive resistance had been withdrawn. And a parallel judicial review had succeeded, in which delay had been taken unsuccessfully by the same legal team. So just to round off the issues I haven't dealt with, the judge was right in this case to grant leave. Originally, he was wrong to set it aside. He didn't even address the test for setting aside. You need a clear case of error. That's our paragraphs 40 and 41. The time had included reasonable pursuit of alternatives, our paragraph 38.2, and the parties had agreed to be bound by a parallel JR that had succeeded and a delay point had failed. And he's written a letter about it. And those are issues 2, 5, and 6, all of which stand in our submission to be resolved in our favour, quite separately from the point of principle. Unless you've got any questions, I'm so sorry I've gone 5 minutes.
No, we've been pressing you. Can I ask about one matter?
Yes.
In relation to the material before the judge,
Yes.
We have the application for leave, and on page 12, electronic page 12, it sets out what was said about reasons for the delay. Is there any other material that we ought to be looking at?
No, because the submissions were all submissions. Mr. Ramlogan was there,
right.
And I specifically asked about this, whether this lack of prejudice was raised at that oral hearing, and it was.
Oh.
But yes, you've got the claim form.
Yes.
You've now also got the letter that had confirmed
Right.
the position. So you see that the applicant was asking for an extension of time, and there was then oral argument. I wasn't there, I can't say any more.
No.
There's no further document.
No,
We don't have a
no.
transcript.
Where do we see the application for extension of time?
The application for the extension of time it was an agreed fact, but in the claim form, it's at page 12.
Oh, that's what I just looked at.
Thank you.
And of course, the judge had given
Yes.
leave on the papers
Yes.
on the back of this,
Yes.
and then took it away.
It is that. Thank you very much.
Yes, thank you. And you, obviously, you can be assured that we have your submissions in writing in addition to what you've said.
Thank you, my Lord.
Thank you. Mr. Alexander, are you able to use the few minutes that we have before we adjourn?
I would suggest that we adjourn and I will start at 2 o'clock.
Well, very well. We can live with that. Right, the court will adjourn.